All right, hi, this is Curt Varone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for June 16th of 2025. Brad, go ahead.
Okay, we're going to start in Virginia. And let me say this before anybody thinks about, thinking negatively about this. And again, we don't know the answers to any accusation, but we're talking about a lawsuit in Virginia. He's seeking $5 million for claiming that he was retaliated against for being a whistleblower. But the really interesting thing to know about this guy is, and then 21, a Georgia jury already awarded him 350 or yeah,
Yeah,
350 in damages, 350,000 damages for the same thing. Now I looked into it. He had alleged, and I'll get into what this is. There he had alleged that his supervisor sexually harassed him, subjected him to a cover up, and then retaliated against him. So that was the report. He got 350,000. So it wasn't just for whistleblowing. It just kind of included it. Here, he claimed that as soon as he was hired, and I'll bet you, I know what you're going to say after this about how people view new people who start making complaints, but he
yeah,
allegedly expressed a concern, right? And I don't really know what that means, how he expressed it, but about how drugs were being managed back in August 24. He was on the job very short time. And then all of a sudden, there's now this retaliation being that he was terminated. And in my thing, and this one I guess I'll ask you, somebody comes in and they're already making waves at the beginning, and I'm not saying they're wrong. Doesn't it seem like it's like it's nature? It's like a personal nature to say, oh, that person's going to be a problem. Let's just get rid of him while he can.
it could be. And again, we don't know enough about the details, but I just think back to my early days, and like I was a little nervous talking to lieutenants and captains when I first got on. And then you never talk to chiefs. I mean, you cast your eyes downward, I mean, you didn't do that. And I think things have changed a little bit, but again, offering suggestions to the point where the chief feels you're going to be a detriment to this organization, even assuming that what he is saying is true, assuming that what the plaintiff says is true, that he made this sort of telling uh, concern aware to the chief, and the chief said, "You know what? We got to get rid of you." That's I don't know. That's a little bit concerning. Not saying the kid is wrong for doing it, but I don't know. I don't know. If he had had a couple of years on, that'd be one thing. And again, this is his second go round now with some sort of a whistleblower lawsuit. So we'll see.
You
We'll
know,
see.
and I feel badly. Again, we're not commenting on the specifics of the case here because we don't know anything more than what's alleged. But I do feel badly, especially if it's, let's say, involved narcotics. This is just hypothetical, right? It involves narcotics where you have a system that could allow me of being accused of taking it because the inspection protocols, like we go through in our must-have policies, where we want it videoed and witnesses every time you open up the narcs box. I could see where, look, I'm being put in jeopardy because of your bad policies.
Mhm.
And right, it's different than saying, to me, a little different than saying, well, I don't think you're making me safe on the fire ground. Listen, if you don't feel safe, quit the job. But if, for example, hypothetically, I'm just inspecting narcotics and I feel like your policies, your inspection policy doesn't protect me, or the way you protect your narcs could get me in trouble, maybe I express a concern in a very gentle way. But I do. I think some people take it offensively, and I don't know how he expressed them and what he said. But you got to be careful. Employers have to be careful because a jury is not going to see this in the chain of command way, right? That we see it. They're
Right.
going to see you hired this guy. He expressed a concern, just quoting them,
Mhm.
and you terminate him. I, if I was in HR, I'd be very concerned.
I would too. And again, there's two ways to kind of think about it. And maybe this kid just had two bad experiences. One down in Georgia and now in Virginia. Maybe, or maybe there's more going on here than what we
Right.
realize. And
Or maybe he's setting
who
him
really
up.
knows?
Who
You
knows,
know?
right? I mean, he could be
Yeah.
setting him up for
Well,
all
why
we.
would they? Yeah, why would they hire him? if to set them up. That's
No, I meant the employee was setting up the employer.
and okay. And I wouldn't, there's a lot of people that think that there's an abundance of people out there setting up, um, whether it's a business or whether it's I had early in my career, I had a close client, close friends of the family, that open a jar of peanut butter and there's a mouse in it. And of course, they're trying to say we planted it there. And, we had it all lab tested and all that stuff. The mouse couldn't possibly have gotten in it any other way. So, but the idea that people are out there creating lawsuits and stuff, intending to, I think is conventional wisdom says it's happening, but I don't think it is. But as much, okay. But
Well, the
I
First
think
Amendment
I think
audit,
I
certainly.
think there are people who perceive themselves to be victims wherever they go, not just at work, not just at the fire department, but and they have a world perspective that feeds into what lawyers do.
Right. And again, we don't know any of the facts. We don't know the
That's
fire
right. No,
department
we don't.
side. We don't know anything. We just know what's
We
alleged.
don't.
But
And this kid, it could be just statistically, it's going to happen that somebody just has two bad experiences, has bad experience in fire department one, and then is a good firefighter, is a good person, and then just has a bad experience in fire department two. It could very well happen.
I don't
So
know. Right. We don't know. But
we don't. We don't.
okay. This next one's also a little troubling on both sides. Interestingly, for the viewers, I was just working on a USERRA policy for a department. And then literally days later, this comes out. So I'm well familiar with it, but at least the policies, USERRA. But here's what we have. We have an FDNY firefighter, and I really want to be detailed in their complaint. It's a lawsuit alleging that FDNY violated his rights as a military veteran and active duty personnel under the federal law, which is the Uniform Services Employment and Reemployment Act. Reemployment's key. And a lot of what he says is troubling, I'll just say, but some of what he says seems off base to me. In any event, here's what he alleges. This is just a lawsuit. He alleges that and he just filed the complaint now. He's a veteran. He's a longtime member of the FDNY. He says that back in 82, he was a police officer with Transit Police. He was appointed as a firefighter in 99. On September 11th, the September 11th, right? He participated in rescue and recovery operations. He was then in 2002 activated by the Army Reserve. He was reassigned, including to the regular Army, and was. It's kind of like a field promotion type thing. That's my ignorant language of it. But he was activated as a lieutenant colonel, and due to a wartime shortage of field grade officers. So he then served, he says, with great distinction. I mean, 3 Bronze Stars, an Army Combat Action Badge, and the Legion of Merit for bravery in combat were his awards. So this is not a schlock person. And the reason I say that is because when you're a judge reading the complaint, or if I'm the defendant reading this, and you read these and you're like, okay, this is the type of person we're dealing with, honorable, courageous, life over self. In any event, so apparently he was notified, and it says, I'm going to quote, he was in a battle zone regularly under enemy fire. He was notified of a 2010 letter that his military leave status with the FDNY was being changed because he was reassigned from U.S. Army Reserve to regular Army. Now, if it went reverse, I could see the problem, but I don't see going regular Army. In any event, that his family was removed from health coverage by the city of New York, which I can tell you what USERRA says in a minute, but in any event, he remained in continuous service with the Army until 2019. And then when he retired from active duty, he sought but was denied medical treatment under the FDNY's health coverage. He completed his service in 18, again, I guess, or 19. Well, prior to release and service, then in December of 18, a little bit before, he submitted a written request to the FDNY for reemployment. And that's what USERRA requires. Now, for the viewers, USERRA also, as one of its many benefits, requires that you return someone to their prior position. But then what he says, and this is the part I take issue with. He says that the FDNY failed to reemploy plaintiff in the position he would have obtained with reasonable certainty if not for his absence. Now, to my understanding, that's not the test. Now, maybe there's somebody who deals with this much more, but having just spent a lot of time in it, that's not the test that I most likely would have attained this position. You got to give it to me, especially, by the way, when it's based on testing requirements like the FDNY does for promotions. There, I think he's probably wrong, but that's not his only issue. In any event, I'm a little confused. Curt, maybe it looks like they denied his reemployment.
Correct. Yeah. That's how I interpret it.
You
Yeah.
can't do that, right? You
Right.
can't do that. And then they also denied him pension rights. You're not supposed to be doing that either.
Well,
And yeah.
I mean, I'm just looking at the dates. If he started as a police officer in 1982. So he's probably, I mean, I started in Providence in 1979. So he's probably, if he started when I started, let's just say, that's going to put him over 65. And I'm not sure what the maximum age
Well,
is
maybe he
with
exceeded the
FDNY.
maximum
So
age. That would be interesting.
I don't know if age has something to do with it. Okay. And I don't know what the program is that when someone who's been away, I mean, it's one thing when somebody goes away for a weekend or a month or even a 6-month deployment. But when someone's been away for this long, you think about last time he was on a fire truck was, 2000, or he probably wasn't, he was in the fire marshal's service. So, but you think about the way that technology has changed, SCBAs has changed, systems have changed, accountability has changed, practices with regard to deconning after a fire, all of those things that have sort of transitioned since then. So you would think a minimum he's got to go back to the academy to get brought up to speed. Uh, so I don't know. I think, and I'm going to ask you because I know you've been studying it. What does USERRA say about an employer's obligation? Are there time limits on it?
So I created this checklist, right? And
Yeah.
I want to review it here, because I think it's a good just to go through some of the benefits, right? So you get protection of pay for 20 days of training, not his issue here.
Mhm.
You get seniority and other rights, and that's, I think, what he's talking about, maybe that he's entitled to seniority and other rights that are determined by seniority. The problem
Mhm.
is that's not promotional, right? That's not promotional. You got to receive all the benefits that the employer paid for. So that would have been his health care, I presume, unless there was a co-pay type, right? Part employee pay.
Mhm.
But you got to continue that. If they were now any benefit that would not otherwise be available to somebody doesn't need to be made available to him, but healthcare certainly is one of those.
Well,
Um,
I think pension is got to be one of the big ones here. And if you recall, it was probably 2 or 3 weeks ago, we had another, I think it was a USERRA case, but it got into someone wanted his pension to include overtime because in New York, I guess New York State, many departments include overtime in pension. I know in my where I
I
come
think so.
from,
I think that's here too.
overtime is, I mean, pension is based on your base salary. It's not based on your overtime. But in New York, it does. And this firefighter a couple of weeks ago wanted his pension increased to cover the overtime that he would have worked, not the overtime that he worked, that was already in
Right.
there, the overtime he would have worked had he not been deployed.
A tough
Um,
one.
that's that lawsuit, and I sense that there's that component in this lawsuit as well. But let me ask you something. If let's say he worked for the city from 82 until 2002, which is 20 years. That's a
Yeah.
long time.
Yeah.
Okay,
Yeah.
20 years. So he's going to probably qualifies for a pension minimum right there. Then
And they have to
he's
continue his pension. They have to
right,
continue any
and then he's
benefits.
deployed for 23 more years.
Yeah.
Okay. Does he retire from the city with a pension of 45 years?
I think so, right? That's the seniority portion. That's the continuing all benefits portion. My understanding is, and I'm not 100%, but it says you shall continue all benefits that were provided as if you were there. That's pension. Now, the part I don't know, this is where I'm kind of hedging, is what if there's an employer either match, employee or employee match, employer match to an employee contribution, or an employee contribution component. I don't know about that part, right? Because they don't typically have to pay for something that the employee would have paid for. They have to continue what the employer would have paid for. So that's the part I'm not sure without looking hard into it. But there are a million of these cases. This is not brand new. So if by chance the lawyer had done, and some lawyers do all the research on the case before they plead it. That's what I like to do before I draft a complaint. I see where other people have failed and succeeded. All right. So you don't make the same false claims or whatever. And maybe, others don't look. So I got to presume they did look and maybe they know what they're talking about. But I got to tell you, the stretch is he should have been given the position that he would have attained with reasonable certainty.
Right.
That is not anywhere in USERRA that I've ever seen.
Yeah.
And then there's
listen,
also
you're gonna call it a benefit that a promotion to lieutenant, captain, battalion chief.
It's not a benefit.
It's not a benefit.
Right.
It's an earned. I don't know. It's an earned.
Well, it's tested for the one, so there's no guarantee how anybody's going to come
Right.
out on a test or where in a test, et cetera. So I don't know. The difference in '02 is, I was talking to a firefighter who's 89 years old and a retired FDNYer, and it's fun talking to him. But we were talking about how weird it was, and I remember it. You used to be down in Manhattan, and you'd see all the guys on the trucks, and the two guys in the front seat had age. They had wisdom on them, right? They used to say. And then after 9/11, a year after, it's like everybody still got acne. And so people were saying they went from age to acne. And it was weird because everybody looks like they're right out of high school on the FDNY trucks. But that opened up a lot of promotions, right? A lot of people got promoted who were younger because unfortunately there are a lot of openings. Maybe that's what he's talking about. I don't know. In fairness, he probably would have been promoted because many people were. So
He was in the fire prevention division. He was a fire marshal. Okay, and maybe those promotions are not tested. I don't know.
I don't know.
And that could be a factor as well. So
I don't know enough about that. But in any event, it's another interesting case. But people really do need to have USERRA policies on their HR side, right? These aren't the normal code of conduct type policies we deal with all the time. But people really need to have USERRA and state law. There's a lot of state law, which sometimes are more strict. They can't be less strict, but are more strict or more beneficial, so to speak, to the USERRA claims. But everybody who's got HR, I hope you have USERRA policies. Very, very important to understand them. You don't want to guess
that's one of our must-have policies.
Well, we'll make it one. I think we should make it one, the USERRA policies. Yeah. Okay. So going to what I think is a total crappy claim, but that's my my opinion. I want to go to LA. There is one interesting thing, and I think all firefighters would even agree with one of these claims. But we're going to go to LA. As everyone know, there's horrible fires, the Palisade fires last year, and destroyed, so much of LA and huge homes and small homes, totally devastating. And so now there's a lawsuit, of course. There's a lawsuit, but it's suing for a couple of things, right? One, they're suing for rekindling. We'll talk about that. You'll talk about that. But they're also suing, which I think is more interesting, is that the city allegedly, right, there's all allegations, made the choice to close this huge water source cistern over allegedly, they stated, economic issues. So they deprived the fire department of this huge access to water, making it very difficult to fight a fire with limited water from tankers, shuttles, etc. That's probably protected under, municipal choice, right? Economic reasons, they're probably protected, but I'm sure the fire departments would jump on this claim too and say, yeah, we wish we had water as well, and didn't have to shuttle it in. But and the other part of this claim is they're saying, well, the fire department allowed something to rekindle, but they admit that the fire was undetectable, I think, underground outside the area of the main fire. And look, we all know fire travels through roots of trees, will travel under brush, can travel underground. But to come after a fire department for you missed a rekindle when the entire freaking county is burning down, to me is insulting. But and where's the insurance? I'm guessing maybe they didn't have insurance. I mean, I wonder, look, I'm sorry to the homeowners, right? But we're firefighters. I'm taking the fire department side on this one. We don't always. And to say that in that massive of fire with that little water that you're responsible for a rekindle, yeah, you're nuts. I just think they're nuts. So, and we often see municipal, right, protections for those types of firefighting. I don't know. Maybe they'll bring in a policy that says you're supposed to do a search or something for that. I just
I'm regularly seeing different types of lawsuits being brought arising out of the Palisades fire. This is, I don't ignore them. I put them in my database, but I don't blog about them because there's just so many. This one seemed to have some interesting aspects of it. That's one of the reasons
I
why.
think,
But
yeah.
I've probably got 40 lawsuits.
No.
Out of this. And this, you think about your average fire department getting hit with 40 lawsuits, uh, would be overwhelming. For LA, it's just another one of the,
Right.
many bad days they've had in their history. So,
And there's look, when you go to Hawaii and you talk about suing the power company,
right.
right? And that's long since, but because the power company knew that it was creating dangers after the same dangers appear, I get all of that. But in this, suing the fire department for rekindle is nuts. But I'm assuming what you found interesting with this was the whole, they, took away the water source.
Yeah,
And I'm sure the fire department was screaming about it too.
they were. Yeah.
But it's economically, generally speaking, municipalities which make a decision for the economy of its taxpayers is generally protected. Okay, this one is just disturbing. We're going to go to Connecticut, and
Boy,
this
oh boy.
post is just disturbing. I know there's more to it underneath, but wow, I read this twice, and I'm like, this is a total. You can't make it up. Anyway, so we have a civil lawsuit. We have a lawsuit in court. This is just a lawsuit. So we're not saying it's true, but if the allegations are true, wow, they're very disturbing. It's filed by a Connecticut EMT against a former EMT who was a colleague of theirs. And they also sue the parents, their employer, which is AMR, the ambulance company.
Mhm.
And this comes out of, I'm going to go into short details, but two alleged kidnapping incidents, not one, but
Well,
two.
here we go. One thing, we've got two with this particular plaintiff, but apparently there was a similar, whether he's got an obsessive personality or whatever, but he apparently had done something comparable a few years prior that AMR should have taken notice of, at least the allegations are, and not put the plaintiff in this case in the position of having to work with this person.
Right. And I'll tell you, if they followed like our criminal background check and our criminal background policy on must-have policies, they probably wouldn't have been in this situation. But here's what we got. So Jane Doe, they protected the plaintiff, but it's a female, right? And the defendant, last name Doyle, they were co-workers at AMR. And there was an allegation. I'm guessing. I have no idea. It sounds like maybe they had a relationship that started fine, but I have no idea. I'm making that up. But it
Well,
sounds like Doyle.
I think there might be some sort of a relationship, but there's pretty clearly some sort of an obsession going
Oh,
on
oh
here.
yeah, way yeah, like
Like stalking kind of
right, like a
obsession.
scary movie obsession,
Yeah.
because and people are going to be floored when we read this. But so the lawsuit alleges that Doyle had a pattern of psychological, emotional, physical abuse. The first in February of 23, and then second the same month. And so the first one, Doyle forcibly brings the female to his home, right? Forcibly brings her to the home, hence the alleged kidnapping, where he verbally, psychologically, and emotionally abused her, threatened self-harm to himself, where he cuts himself, and then locks her in a bathroom. That's why I was thinking there's some sort of relationship that, at least in his mind, there's some sort of
I think in
relationship.
his mind there was, yeah, right.
Yeah, and again, I'm guessing, but and then on the second incident, he finds her after their shift ended, which
Mhm.
makes me question, okay, when was this first reported to AMR? Why are they still on shift? But
Well,
he
that's in
brandished.
the, I don't know if you got a
Oh yeah,
chance to
no,
go
that's
through
in
the
it.
complaint.
That's in
Yeah,
it.
and the
Yep.
complaint says that she said after the first one, she didn't, apparently she didn't explain everything that happened after the February 5th thing, but she said, I can't work with him. Please do not.
And they keep them together
And-
on shifts or in
right.
station, right? And I can't believe he's employed after that first one. But in
Yeah.
any event, maybe they're investigating, right? Maybe
Yeah.
because this is only a couple weeks
Well,
later.
no, I don't
Maybe
think
they're.
she reported it. I think that's part of it, that
Oh, the February 5th.
her parents encouraged her not to report it or not to say that she was kidnapped so that he wouldn't get in trouble. So she,
I mean, I don't even get how. I'm sorry, I'm not going to speak about the parents. I have no words for that. How do you say that? In any event, so apparently they're working a double shift together on the second incident, February 22nd. He finds her, he shows a firearm, forces her into his vehicle again, then drives around at high speeds, right? Collides with another vehicle.
there's a police chase.
There's a police
They're
chase.
being
Yeah.
chased by the police.
Throws the gun out or something like that, but then gets a duffel bag which has handcuffs, duct tape, and other items. I mean, this is a bad
Oh yeah,
movie, and I'm sorry for
you
this
keep
woman.
that in your car, don't you? You keep
Oh,
that.
all the time, just in case I want to have a random abduction. Like, Jesus. And look, you can fix everything with duct tape, but that is not what this is about. In any event, there's all these, right? Kidnapping, assault, negligence, infliction, emotional distress. I don't clearly intentional infliction, vehicular negligence, all this stuff. But she sues correctly, right? AMR and him. I just, how does that happen? But the important part of this is they talk about you should have done a background check. There was a criminal record of offenses, and I'm going to say this, and I've been complaining about it when I speak at FDIC, when I speak everywhere. I've complained about it to New York senators and assemblymen, because it's a big problem in New York. We aren't mandating background checks for EMS and firefighters. And in some states do, right? Many states do. Many states prohibit you from having certain crimes that you can't have, like even petty larceny. If you're convicted of petty larceny in the last couple of years, you should not be walking around people's homes, right? Or dealing with unconscious patients. All of that. Why aren't we doing that? And I'll bitch about New York, and there's like at least another 15 states I found that don't have background checks. They don't allow you to fingerprint anybody and run a background check. And so they won't do the federal fingerprint. How is that possible? How is that? We are people of trust. Well, you first verify that they're trustworthy before you put them in a position of trust. You go to the police, right? You join the police academy. They're doing psychological testing, criminal background testing, personality testing. But the fire service,
I
hey,
do
come one,
wonder
come
whether
all.
even a state like New York, they're allowing them even in law enforcement to do the kind of background checks they ought to be doing.
Right.
And then they complain when the police have a mishap, but the person that created the mishap was there because of the restrictions you placed on doing background checks and psychological checks and so on.
Right. And with private employers like AMR, it's even worse. They may be government contracted, but they're still a private employer. They have almost no access to a fingerprinted background check. I just want to share this because it's a joke, but it's true. And well, it's funny, but it's true. Somebody said to me, I want to do finger background checks. How do I do it? I said, easy. Every single employee must apply for a gun permit. If they if they're allowed to have the gun permit, then you're kind of accepted. It's not foolproof like we'd like because you don't get the results. You just
Well,
get yes or
yeah.
no. But
Um,
I don't know
how
what to
do we
come up
get
with.
how do we get the business necessity associated with getting a concealed carry permit? But
Well, we're going to require you to have firearms training in case you encounter a police officer with a firearm who's downed. I mean,
oh
we all
yeah,
have had that,
yeah.
right? I think I could justify it. But again,
I
they
like
said
the
come
way you
up with
think
something,
about it, but
right?
but
I couldn't make anything better up to
the
get you.
The reason I wanted to put this one in here isn't so much against AMR, certainly isn't against Bradley Doyle. He needs help. Someone like that needs help. The family, I'm not sure why they, instead of like covering for it, they didn't address it. But the reason I wanted to cover this one, this is not an isolated situation. And it's not isolated to certainly AMR and private industry. This is happening in fire departments as well, and we need to be prepared for it. When someone comes to us and says, I'm firefighter A, I cannot work with firefighter B, there may be a limit in terms of what they say about why I can't work with firefighter B. And I know it's a nuisance, and I know as a shift commander responsible for staffing when somebody, I can't work, you're making my job impossible. But this, I think, in part developed because AMR didn't separate them after she said, I can't work with them. Please don't schedule us together again. So that's one of the reasons why I wanted to get this one out there. I think there's an important lesson there. And again, I'm sympathy for the plaintiff, sympathy for the perpetrator, who I don't think was in his right mind and wasn't, didn't deliberately, commit this. And he's no doubt, I believe he's already been sentenced, if I'm not mistaken. But
Be committed, not sentenced. But
yeah, so I think that it's an unfortunate situation where there's no winners here, but I think there's a lesson for staffing and when and I know when I left Providence, my brother ended up in my position several years after I left as a shift commander, but when I left, I don't recall anyone having one firefighter having a restraining order against another firefighter. By the time he retired, there was at least a dozen among 500 people, but there was a dozen that had restraining orders against other firefighters that the court ordered these two can't work together. And that's difficult. It's difficult to manage your workplace like that.
yeah.
But here's an example of what can happen when you don't honor that
And I got to
request.
tell you, one of the things that crossed my mind, it's a step away from this, but if I was, AMR and the woman came in, the victim came in and said, listen, he was cutting his wrists, right, outside. Now, AMR's not the government, so they don't have violations of your Fourth Amendment rights, but change it for a second. Now it's a fire department. She goes and says to the fire department, a municipality who cannot violate your constitutional rights because they're a municipal entity, and says he was cutting his wrists. Would you, and this is an off the cuff question, but would you say, show me your wrists to the person? I want to verify and investigate her story. She claims you were doing these things, cutting your wrists. Would you say, show me your wrists? Or would you say, no, Fourth Amendment violation, I need a search warrant?
No, I don't think that's a search. That's not and it certainly isn't a Gary. It's not testimonial.
Right.
Okay.
Well,
So
it's not. I mean, you're the expert on Garrity, but
yeah.
that's not like
It's not testimonial. No, Gary, the right to remain silent is not testimonial. You can be required to be fingerprinted and photographed.
okay.
That's now, I don't see a Fourth Amendment issue.
So had it been brought to their
You could try to
attention.
make it one, and I'm not sure you could, but you could try to argue it, but I'm not seeing it.
Okay, let's finish up in West Virginia over, and I'm gonna take a hard stance on this over the dumbest lawsuit. Now, close to them. No, but the court dismissed it, so I'm not out of my mind saying this. But there's funny parts of this to any firefighter when you listen to the facts. So we're in West Virginia. An appellate court affirmed the dismissal of this lawsuit, right, which is normally where these end. They claimed that 911 operators mishandled a carbon monoxide call. But here's the thing. So this minor I guess there's a power outage, starts a generator. The generator, we've seen this a million times, right? The generator is too close to the house. The house is filling with carbon monoxide. It's kind of funny because they said they perceived fumes in the home. Well, not from carbon monoxide, you didn't, hence colorless, odorless, but maybe from the gas, of course, right? But they said they opened the windows, they opened the doors. They called 911 for the fire department who was en route. And then they said, well, but then we were kind of like out of our mind because of the fumes. We called back the dispatcher. The dispatcher said the fire department's on the way. So again, they dispatched the fire department and then said, well, but the dispatcher didn't show any sense of urgency and didn't seem to know much about carbon monoxide. That's not their job. They dispatched the fire department, and we do know a lot about CO. In any event, and they're en route. And while they're en route, I guess, because of they claimed this distinct lack of knowledge, the guys who were out of their mind, they claim, got in their car, to which they don't remember, and drove to the hospital under, as being a little bit deranged from the CO poisoning. And he says, I have no memory of driving, but I ended up at the hospital. And so they blame this all on the 911 operators. The court, thankfully, right, says no, right? This doesn't rise to the standard it needs to rise against. You have statutory immunity provided by a law. You have immunity. He doesn't even really say it may have been negligence. He just says it doesn't rise to the severe conduct to get around immunity, which is reckless, wanton, almost intentional. And then he even says, listen, this went all the way through trial. We're not going to allow you to amend your complaint to add new facts or new allegations. You're out. But this is the stuff that you talk about. Why don't we have money to buy fire trucks? Because our insurance companies and everything, we're spending all our money on this type of litigation. And I have no sympathy for this. They dispatched the fire department, right? If they didn't dispatch the department, it'd be a different issue.
In addition, you've got clearly the public duty doctrine would apply in this situation. You've got, I think they cited the statutory immunity, but the causation part of this, where's the causation? I mean,
Right.
the causation was your generator. Now, yeah, if they had said, oh, we're going to dispatch an EMS unit, you wouldn't have driven, but you didn't get in an accident on the way. So where's the causation that the harm that you suffered was caused by the dispatcher, you
Right.
know?
And
And yeah,
yeah, I was going to say, we don't know if the fire department were medics or EMTs, right? I mean, they could tell if somebody's red from carbon monoxide poisoning. They could
what
do you know,
did I misread it? Didn't they transport themselves before the fire department
they did.
really?
They
They,
did. That's why they got in. But that's what I'm saying. If the dispatcher dispatches the fire department, who are also EMTs or paramedics, right, as first responders, what the heck more should the dispatcher have done? And the dispatcher usually says get outside, right? Nor I'm betting here the dispatcher said, because it's normal protocol, go stand outside. If you think there's CO in your house, get outside, not open the windows and doors. What were they going to say? Don't do anything crazy that you're not going to remember later, like getting in your vehicle?
one incident that really stood out in my mind when I was with Providence, I was a battalion chief at the time, and we were going out, every night. We made the rounds to all the stations. It was like 6:30 at night. We're going out to the rounds, and at the watch desk. This is back when we had a watch desk. There's the firefighter and actually a couple of firefighters, and there's a woman and a child, and the woman seemed like she was drunk. She just and she's like babbling incoherently, and the firefighters are like, they don't know, like, what do we do with this woman? So we kept talking to her because there was obviously something, and I'm not sure what caused us to do it, but we had the engine that was assigned to that station go to her house and see what was going on, and it was high carbon monoxide. It was like off the charts, over 1,000. It pinged our meters at the front door. It pinged the meters to 1,000. And but she came across as somebody who was impaired, and she was incoherent. She couldn't explain how she got there, where she was going, what the problem was. And you would think that she was drinking if you had, you didn't know anything else. And fortunately, they didn't just, usher her out. They took it, realized what was going on, and we got them and the family and everybody safe. But um, reading this, I was wondering whether or not the dispatchers are thinking that when someone sounds like they're impaired or just being an
Yeah.
idiot, that there may in fact be something else going on here. And
But if
so
if the dispatcher didn't send somebody, that would be one thing, right?
exactly, exactly, exactly.
That's what gets me about this. It's not like she hung up and said, "You're obviously an idiot. Go away. We're not sending anyone." They said they dispatched the fire department. That's what
Right,
should
right.
happen. So I anyway. Well, that is all of them for the week, and that is some really disturbing and interesting.
Yeah,
We don't use the word disturbing much on our show, but that is definitely this definitely had that in it.
yeah. Well, we'll see what next week's cases bring. So
Can we just go back to harassment, discrimination, and retaliation? It'll make me feel much more comfortable.
we will see what the future holds. So, all right. Well, that'll do it for another edition of Fire Law Roundup. Brad, thank you, and we'll see everybody again next week.